Oops. Hi there, I see you. I know some other folks will probably be joining us. Either way, we want to record this and talk about probate. So we have only about a half an hour for this lunchtime seminar talking about probate. And I thought it was important to talk about this topic because a lot of times we spend time on estate planning, but we don't spend as much time on probate. One, because it's one of the more uncomfortable topics to discuss, as it's really talking about once we pass away or once a loved one passes away, what the legal process is, what that business of death essentially is. And a lot of those things, a lot of those processes or the parts of the process remain kind of a mystery to us. And I think if we knew more, if we had more information, it would inform us and help us to make better decisions with our estate while we are living. Okay, so let me figure out how I can advance these slides. All right, there. Okay, so everybody understands what a will is, right? So when we're thinking about probate, one of the initial documents that is needed when probate, which is this legal process after death, is started, generally is the last will and testament. Now, there are circumstances which we will get to when someone dies without a will, and probate is definitely required in that situation. But some people think because you have established a will that there is no need for probate, and that is a misnomer. In fact, when you're drafting your will document, you are identifying someone to act on your behalf when you're no longer here, or on behalf of your estate through this will. In order for them to be authorized, they have to go before the surrogate court or the surrogate's office. Okay, so folks are aware that through your will, you're going to be transferring property to whomever, your beneficiaries, maybe your children, maybe your loved ones. It can be charity. People know that, but they think that just by me writing this in a document, then the person who I've authorized through the document to do this transfer, they now know what my wishes are and they're authorized to do so. But again, no, they are not. They will have to present your will at the surrogate office in the local county, whatever that county is, and they will many times have other requirements. So we're going to move on to those slides and address that stuff. So after death, this is called the post-mortem phase. Your person, whoever you've identified as the executor in your will now have to carry out your wishes. Okay, but because the laws of New Jersey say you can't just take this piece of paper and just start doing whatever you want, you need to have the original document. This is something that I have run into in my office, where families come back to me upon the passing of their loved one. They know that a will exists, or they may even have a copy of the will, but they can't find the original. This is a problem because the surrogate's office in whatever the county is that the person has passed away will not open what we call probate. They will not open an estate file without an original will. Okay, so it is very important that if you have a will, that you know where it's at, or that people who will be carrying out your wishes know where the original is at. There was a time probably when attorneys held on to original wills. That is not common practice anymore. So now we generally will give the original will to the person who is establishing that will, and we keep copies. So while we can testify to the fact that the will was signed, that the person had capacity, and here is a copy of it, if you're needing the original will, which your loved one or your executor will need, they need to know where it's at in order to start the process of probate. Okay, so they will need an original will. In most cases, especially if the estate is over $50,000, the person who is acting as the executor will also need to be bonded. This is a insurance bond that says that they're going to carry out the wishes of the decedent to the letter of the document. Why this can be a problem is if folks have like any sort of like financial hiccups in their history that might cause credit issues, they may not be able to be qualified for the bond. And this can obviously be problematic for the person that you want to act as your executor if they can't be properly bonded. Okay. What then happens is that person usually has to file a document with the court, has to file an action with the court, asking the court for permission to stand in as the executor without bond. And that's, of course, up to the court. And sometimes the beneficiaries may have something to say about that. So that can be a drawn out process. Also, your executor now is required to send notice within a certain number of days of opening up the estate file at the surrogate's office to the next of kin and or beneficiaries. Many times the next of kin are also the beneficiaries of the estate. But in any case, the notice must go out. So this is a responsibility of your executor, okay? They then have to establish estate accounts once they've been authorized by the surrogate's office. They will be responsible to pay estate expenses, whatever they may be. There may be some, what I see commonly are credit card expenses, sometimes medical expenses, especially if the person was ill and they, had limited health insurance. The executor, if there's enough in the estate to cover those bills, will be responsible to pay for those. If the legal expenses, tax, professional expenses, all those sorts of things are expenses that will come out of the estate and will be the responsibility of your executor. And then ultimately, after all those things are taken care of and the executor who's entitled to some percentage of the estate for their work that they're doing, they will also deduct out their fee, and then the remainder is distributed to beneficiaries. These things, this part of the process are often unknown. So people don't recognize the amount of responsibility that is laid upon an executor. So I think it's important to know this, that whoever you are selecting will have to carry these things out. And if they, for some reason, cannot or just feel like they're overburdened with other things to do, that they can't carry this out or don't wish to carry it out, many will hire an attorney who will assist them with that process, but it's expensive. Okay, so there are those expenses to be considered as well. Okay, so mind you, this is just when you have a will and you have not taken any additional steps to avoid probate. Okay, so again, we talked about what if you die with no will, what then happens? Someone, instead of an executor, someone has to be appointed as what we call an administrator. And essentially, this person is going to do the same exact thing that an executor would have done, but you, whoever deceded, you who have now passed away, didn't have a say or don't have a say in who that administrator will be. In fact, the state of New Jersey has a what we call kind of an intestacy chart or intestacy rules and laws that say when someone dies without a will, this is the order that things must be done. Okay, so generally speaking, if you die with a spouse, your spouse or a living spouse, that spouse would then be the next in line to be an administrator. If no spouse, but there's parents, then your parents, one of your parents can step in as administrator. If no parents, but children, then children. If no children, then siblings. Okay, now, if more than one person is on equal standing, that means that essentially everybody's going to have to agree who the administrator is going to be. As you can imagine, in many families, this is a problem. And so I have, most times when I'm in court, this is one of the top issues that I'm in court for in probate, which is there is no will. 3, 4, 5 people have the right to be administrator, and not everybody can agree to who that person will be. So then multiple folks may be represented by counsel, and we all have to make our argument to the court about why this person is more able or should be appointed as the administrator for the estate. So as you can imagine, it's going to be very costly in terms of money and in terms of time. And let's not even get into the emotional expense that this can cause to families. So much family breakdown. I'm actually dealing with one right now that involves a stepmother and the natural children of a decedent who were not shared with the spouse. And this has gone on now for 9 years. When I came in, it was at the 7-year mark, and now we're at 9 years. So we finally think that we've come to a resolution that involves the selling of some of the estate properties and then the distribution of the proceeds. But it's been a headache. My client, who is the stepmother in this situation, has been in my office numerous times in tears because it's just heartbreaking, and it's been ongoing for years. So these are things that are not often known or discussed when talking about the process of probate, and especially in circumstances where there is no will. Okay. And again, just like in with an executor, the administrator most likely will need to be bonded. They will have to have some sort of insurance, meaning they will more than likely have to be able to qualify with their credit status. Okay. This is just a chart. Then I will share this. I'm going to send this out by email to those who have registered, just so you can look at the way, like I was kind of referring to before, the way the state looks at who is entitled to what upon your passing if there is no will. So if you die intestate, okay? I think it's really important to know that, especially I get stuck a lot of times around, let's see, this fourth area down here where a spouse and children of the decedent are remaining after the passing of someone. And this is like what I was just referring to, the blended family situation, and there's no will. A lot of times folks think that if they die with a spouse, everything goes to their spouse. But if they have children that did not belong to that spouse, the state says no. Most of it will go to your spouse, but there's a good portion that will also go to your natural children in equal parts. If you are estranged from your children, or you would not have wanted it to go to them, there's nothing you can do if you have not taken steps during early estate planning. The state runs it. This is something, again, when families come to me as their attorney to assist with probate, I have the unfortunate, I guess, responsibility to share this information with them. Most of them don't know. It will mean also that children, sometimes stepchildren, who had a parent relationship with the decedent and who were loved and cared for by the person who passed on, that they will essentially be disinherited. So these are reasons that we need to know this information. We need to use wisdom in our estate planning. We don't need to wait until the last minute, and we need to express our love to those who we live with and love on while we're living, by putting plans in order. Okay, so this is what we need to be mindful of when dealing with probate. Okay, so I kind of already have discussed some of these problems already, but obviously some families don't want court involvement and oversight, but it's guaranteed when you go through the process of probate. Meaning, if you have a will or if you don't have a will, your estate essentially must go through probate. It must. Therefore, oversight of a third party. And depending on a myriad of things, people just don't want that. People want their loved ones to be able to immediately get to work and start carrying out whatever it is they want them to carry out, or immediately benefit from what they've left to them. And in the cases that we've already discussed, it just doesn't happen that way. Okay. Again, the need for bonds. So I have run into, in fact, I'm dealing with right now, I had to file paperwork with the court for siblings who are in agreement with administration, but neither party is able to get bonded. So now, because there is nobody else in line and we can't get them bonded, we need to make a request to the court that they can be appointed without bonding, which ultimately will be up to the court. I'm hopeful that it'll be up to the court. So these are things that we run into, problems that we run into with probate. Again, it can be lengthy. It can go on and on and on, depending on if the parties can agree. Even when the court has spoken on an issue, sometimes what the court has ordered to occur Takes a long time. It can take a long time. It can take months. Right now, again, with the situation that I referred to earlier, where there is a blended family, the court has ordered that one of the state properties be sold, and it was listed within 30 days of that order, but it's still on the market. So that these are factors that we can't control. And that means that the loved ones who are entitled to the proceeds, they have to wait. So this is something that you run into with probate, okay? And then certainly the need for attorneys. People can represent themselves because they don't know a lot of the ins and the outs of the rules and the laws around intestacy, or even distribution, even with the will in place. They most times find themselves at an attorney's office, who will generally charge percentage of the value of the estate. Even if they don't say it that way, they're calculating it that way, okay? So if the estate is worth multiple six figures, you can imagine their percentage may be large. That will likely be more than what would have been paid at the highest level in estate planning. So that means that even though you may not spend the money up front in estate planning, you're pushing that expense down the road to your loved ones who you really just want to benefit with your estate. You don't want them to have to spend, their own money, or spend down the money that is left in the estate to carry out what they have to do through probate. Okay. And then of course, family disputes, heartache. Initially they were in agreement, and then now all of a sudden they are not in agreement. Now, they thought one person was the better administrator. Now they feel like they're the better administrator. So, not dealing with these things on the front end can certainly cause, devastating, heartbreaking breakdown in families. And we really don't want that. Okay. So, can it be avoided, right? So all of that information ultimately to ask this question: how can I avoid this? I don't want that. I don't want the court involvement. I don't really want whoever I'm naming to be concerned about, like, if they have had credit issues, are they going to be able to get bonded? If they can't get bonded, do they have to hire an attorney? Do they have to, be in court? And they're already dealing with the grief involved with me no longer being here. I just don't want that for my loved ones. How can this be avoided? It can be. In many cases, it can be completely avoided. Sometimes things will fall out, but for the most part, it can be completely avoided if you are working with a professional, a law office, an attorney like myself, who can help you, who can look at everything you have and say, hey, here are the best ways that we can transfer whatever your interests are to your loved ones, your next of kin, your beneficiaries, without the involvement of probate or the surrogate court or the probate office. Okay. Here are three of the ways that we can do it. We can put all of your assets in a revocable or an irrevocable trust. Now, the simplest way to do it is through a revocable living trust, which I encourage all of the time when folks come to me. Now, I encourage it, but not everybody does it. That is one of the wonderful ways to pass things straight on to your beneficiaries and to empower whoever would have been your executor, we name them a trustee, to immediately start working without the requirement of bond. Okay, so they can immediately start moving things around upon your passing when we put things into a trust. Okay, another way that we can do this is, especially in real estate, but it can also happen in other ways, which we'll get to, is when you name someone as a joint owner of your estate, a joint owner of your property. We do this through a deed, generally, naming someone as a co-owner with what we call the right of survivorship, meaning that upon your passing, it immediately transfers fully to this next party. It can be one person, it can be multiple people. Sometimes folks don't want to do that directly on a deed because they're saying, oh no, that means they're going to immediately be co-owner with me. And I don't really want that. I don't want them to have to sign a deed if I want to sell it, and so on and so forth. If that's the case, then I would say we got to do the option number one, which is a trust. Okay. But we talk about that on a case-by-case basis. When you come to me for your consultation about avoiding probate for your life and your estate. Okay, so you can put it in a trust. You can transfer a deed with the right of survivorship to whomever your loved one is, or you can designate a pay on death beneficiary for your retirement accounts. Your life insurance policies, of course, we know about that, but also your bank accounts. Many folks don't know about that because we go to TD Bank or whatever the names of the banks are. I'm not sponsored by anybody. Citizens Bank, well, wherever you bank, wherever your financial institution is, we can just open up those accounts. And generally speaking, they don't ask you, okay, who's the beneficiary? So we open the accounts and we never address that. I encourage you, no matter what, even whether you establish a trust or not, to make sure that you've addressed who is your pay on death beneficiary. If you have a trust, it should be your trust. If you don't have a trust, then you need to name whoever you want to immediately be able to access those liquid assets. Okay, so you can do that by designating a beneficiary so that we don't, those things by the function of law and designation will immediately transfer to whom you wish to gift. Okay, so it can be avoided. Certainly, though, I think you should have a discussion with an attorney who is experienced in this, who can look at what your individual goals are, because absolutely they vary from person to person. Your assets, will vary from person to person. And there are some simple ways to do it, but you should be advised in doing so. I had somebody call me who told me she wanted to transfer 6 figures to her children, and she was just going to, she called me, it's funny because she thought she was just going to go to Staples, print out a piece of paper and say that she wanted to do this. And I said, certainly you can, but I think that that's not advisable, and that's why you call me. So certainly it's better to speak to someone at a minimum, have a consultation, right? Know everything about what's best for your estate. Don't think that you can just completely do it on your own and everything will be carried out the way you wish. If you want to make sure to help your loved ones avoid the headache, expense, and all of that of probate, then you certainly need to do proper estate planning through talking to an attorney. And I would be very happy to be that person for you here in the state of New Jersey. I'm going to stop my share of my screen. And I want to just make myself available to you. Certainly, if you have any questions, you can put some. If you have questions now, you can put them in the chat. Let me see if I can make this go. Trying to change the view here so you guys. If there are any questions, you can put them in the chat. But I believe most folks will see this on the recording, which I will be posting on our social media platforms. You can certainly email your questions to me at Chandra@Betner-Gray-Law.com or to info at Betner-Gray-Law.com, and we will try to answer your questions. But more important, I think, is that you schedule a consultation. You can do this on my website at Betner-Gray-Law.com. If you pre-register for this event, we will be sending out to you a link, a special link that will allow you to schedule your consultation at a discounted amount. If you have not registered, you will just go to the website and book your consultation there, because we really do need to talk. So I want to make sure that your estate plan is tight, is airtight, so that you can help your loved ones, your executors, avoid probate and have smooth sailing, because really the last thing they want to have to deal with when their heart is already broken from the loss of you is to have to figure out navigating this legal process. And we can help our loved ones avoid that and give them the gift of our estate planning, our pre-planning. So even if you've already done an estate plan, but you're not quite sure if it is carrying out what you want, as a part of your consultation, we would be able to look at what you've already done and say, hey, this achieves everything you wanted to achieve, or there's a better way to achieve what you'd like. So again, you can do that by shooting us an email, by going to our website and booking a consultation. And certainly you can give us a call here in the office as well at 609-479-1227. I'm gonna just put all of that in the chat for you. Right now, our phone number as well. And if you are watching this as a recording and you're not able to see the chat, we'll make sure to post that same information underneath in the comments of whatever platform it is. Most likely it will be Facebook, perhaps even Instagram, and you'll be able to see this information in the comments. Okay, so we look forward to hearing from you. Hopefully I'll be able to help you and your family, and hopefully not at the probate stage, even though I do that. I'd love to help you avoid that. So again, it's been a pleasure. I hope you enjoy the rest of your day, and we'll talk to you soon. Take care.